po, ma'am. Next, please.
After Miss Isa, we have, yes, next, we have Miss Fatima Katucho.
Let me set up lang po for our nababate po.
Yes, you're audible. Go ahead.
Permission again po, may ako po 2 accounts. Ano po itak laptop, itak PowerPoint, and my camera on my tab. My assigned case, article for this morning are articles 13, 14, and article 13, 15. Before we proceed with the definition of Article 1314 or the provisions of Article 1314, let us again reiterate what Article 1305 states, the definition of contracts. Again, contracts is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some services. And Article 1314, any third person who induces another to violate his contract shall be liable for damages to the other contracting parties. This article penalizes unjustified interference by a third party in a valid and existing contract. The law protects the sanctity of contracts by making third person liable for damages if they induce one party to breach the agreement. To be liable under Article 1314, the following must be proven. There are 5. First, there is a valid contract. Second, a third person who is not a party to the contract interfered. Third, the interference was intentional. Fourth, the interference induced party to violate the contract. And last, damage or injury was caused to the other party. I have here an example. S, a movie actress, has 1-year contract with XYZ Studio. If F, a friend of S, induces her without any unjustifiable cause to break the contract, then XYZ Studio can sue F for damages. Let me present to you a short clip. I will try to
Petitioner, the House of Mayfair wall covering products in the Philippines, tried foul and his former dealer of the same goods, here in private respondent, purchased the merchandise from the House of Mayfair in England, FNE Trading in West Germany, and sold said merchandise in the Philippines. Both the Court of Origin and the Appellate Court
Scott,
rejected
maybe
cases
you
that
can
private
you
respondent
or
engaged in
the other
civil
mic
unfair
and then you
competition
can
within the
play
context
this
of Article
like
28 of the Civil Code. In the suit for injunction which petitioner filed before the RTC NCR station in Manila, petitioner pressed the idea that he was practically bypassed and that private respondent acted in concert with the of misleading Mayfair into believing that the goods ordered by the trading firm were intended for shipment to Nigeria, although they were actually shipped to and
okay na po.
sold in the Philippines. Private respondent professed ignorance of the exclusive contract in favor of petitioner. Even then, private respondent responded by asserting that petitioner's understanding with Mayfair is binding. Nevertheless, one circumstance which respondent court overlooked was petitioner's suggestion, which was not disputed by here in private respondent in its comment, that the House of Mayfair in England was duped into believing that the goods ordered through the FNP trading were to be shipped to Nigeria only, but the goods were actually sent to and sold in the Philippines. A ploy of this character is akin to the scenario of a third person who induces a party to renege on or violate his undertaking under a contract, thereby entitling the other contracting party to relief therefrom. The breach caused by private respondent was even aggravated by the consequent diversion of trade from the business of petitioner to that of private respondent caused by the latter's species of unfair competition, as demonstrated no less by the sales effected in spite of this court's restraining order. This brings us to the irreparable mischief which respondent court misappreciated.
Again, in the
Nakamaglita na. Nakamaglita ba?
again in the in the first example that I have given, where S, a movie actress, has 1-year contract with XYZ Studio, if F, a friend of S, induces her without any unjustified cause to break the contract, then XYZ Studio can sue F for damages. In this example given, the liability of F does not arise ex contracto, for he has not a party to the contract. Again, let's define what is ex contracto. It refers to an obligation or liabilities that arise from a contractual relationship when someone fails to comply with the terms of a valid contract. They may be held liable, as in ex contracto, or it is a Latin word which means from contract. Also, let us note that in the same example, F cannot be held liable for greater damages than S. A contrary answer would lead to result at once inappropriate and unjust, as in the case of Dayworld versus Corporation 39 Phil 587. In the same opinion of the Code Commission, F's liability would at most be solidary with S because of his commission of a tort. By the way, the commission of F here is a tort and not a breach of contract. What is again a tort? A tort is a wrongful act or omission independent of a contract that result in injury or damage to another, and for which the injured party can file a civil lawsuit or claim compensation. And in the case of U versus Court of Appeals, U was the exclusive distributor of House of Mayfair products in the Philippines. And then he filed a case after a former dealer bought the same product through a third party abroad and resold them locally, bypassing U's exclusivity. U claimed that the third party misled Mayfair into thinking that the product were for Nigeria, but they were actually shipped to the Philippines. The Supreme Court ruled U's favor, stating that the respondent's action resembled unlawful interference in a contract under Article 1314 of the Civil Code, since they induced a breach of U's inclusive agreement. The court also said the damage to U's business, reputation, and goodwill was irreparable and justifying injunctive relief to stop the unfair sales. Let us now proceed to Article 1315 of the Civil Code. Again, contracts are perfected by mere consent, and from the moment the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to the consequences of which, according to their nature, may be in keeping with good faith, usage, and law. Article 1315 of the Civil Code explains the perfection of consensual contracts. A contract is perfected or become valid and binding once there is a mutual consent between the parties of the element. So there are two elements of this contract: the subject matter, or what the contract is about, and second, the cost or consideration, the reason or payment of the obligation. There is no need for delivery or written document consent. Consent alone makes many contracts binding unless the law requires for a form like public instrument or for sale of real property. Let us now proceed to subtopics under Article 1315, which are the first, consensuality of contracts; second, the contracts are perfected; third, perfection of consensual contracts; fourth, consequences of perfection; fifth, what the buyer should have made; and sixth, the duly authorized to effect cancellation of an otherwise perfected contract. Given an example in Article 1315 under consensual contracts. Consensual contracts, the article stresses the consensuality of contracts which is perfected by mere consent. So in this example, Juan offers to sell his car to Pedro for 200,000 pesos, and then Pedro says, "I accept your offer." At that exact moment of mutual agreement on the car, which is the object, and the price, which is the cost, a legally binding contract of sale is perfected. Juan is now legally obligated to deliver the car to Pedro, and Pedro is now legally obligated to pay Juan the 200,000 pesos. So they don't need a signed document or the physical transfer of the car and money for the contract to exist and be enforceable unless specific laws for vehicle sales require certain formalities, which would be exceptions to pure consensualism, and a mere consent has created the legal obligation. Also here the case of Salvador P. Malbarosa versus Court of Appeals and C. Development Corporation, JR number 125761, April 30, 2003. What happened in this case? CDC offered Malbarosa a settlement package including a company car via a letter requiring his signed conformity of acceptance. However, Malbarosa received the offer but did not sign immediately. CDC, not receiving Malbarosa's signed acceptance, withdrew the offer through a letter. And then Malbarosa later claimed that he signed the acceptance before the withdrawal letter reached him, but only communicated this letter after receiving the withdrawal. CDC sued to recover the car, and the trial court ruled for CDC finding no perfected contract, ordering Malbarosa to return the car. The Court of Appeals affirmed the trial court's decision. Let's try again if we can hear this out.
of Salvador P.
Ano mo sa mic, ventilated phone, i-mute, tapos itim laptop, wala. Pig-open lang siya ang kanan mo, mic at laptop. Siya may feedback. Kaludo na.
In the case of Salvador P. Malvarosa versus Court of Appeals, we delve into the intricacies of contract law. Picture this. From March 16 to April 3, 1990, Malvarosa had over 2 weeks to accept an offer from SEA Development Corporation. He claims he accepted on March 28th, but here's the catch. He never sent the signed letter back. This is crucial because a contract isn't just about verbal agreement, it's about communication. The law states that a contract is only perfected when the offerer knows about the acceptance. If the acceptance isn't communicated as the offerer specified, it's treated as a counteroffer, which the original offerer can choose to accept or reject. Moreover, if the offerer revokes the offer before the offeree accepts it, the acceptance is void. So in this case, without that letter reaching SEA Development, no contract was ever formed. It's a clear reminder. In the world of contracts, clarity and communication are key. In the
Let us now proceed to the next subtopic under Article 1315, how contracts are perfected. Okay, contracts are perfected by three contract types. First is consensual contract, second is real contracts, and third is formal or solemn contracts. Consensual contracts are perfected by mere consent. Examples of this are contract of sale, which is relevant to Article 1315. Second, real contracts are perfected by delivery of the object. Example are deposit and pledge, which is relevant to Article 1316. And third, formal or solemn contracts, which require a special form and simple donation inter vivos of real property in relation to Article 749. In this given example, under perfection of consensual contracts, again, consensual contracts are perfected the moment there is an agreement, consent on the matter and cause or consideration. We have here a scene in a coffee shop. The character in these scenes are Anna, a small cafe owner, and then Ben, a local furniture maker. So in this setting, inside Anna's cafe, she is discussing with Ben about getting a new wooden tables made for her shop. Anna said, "I love your design. I'll order 5 of those wooden tables for 5,000 each." Then Ben said, "Deal, I can have them ready in 3 weeks." And then Anna said, "Great, I'll pay upon delivery." So at this point, consensual contract is perfected, and then there is an agreement on the subject matter, which is the wooden tables, and the cost or consideration of 5,000 pesos per table even though no payment or delivery has occurred yet. And then the contract is legally binding under Article 1315 of the Civil Code. And then on the consequences of perfection, we have here the information from the book. First, the parties are bound to be the fulfillment of what has been expressly stipulated under Article 1315 of the Civil Code, and compliance thereof must be in good faith under Article 1159 of the Civil Code. Note, if the true intention is not expressed in a written agreement, in case one has been made, the proper remedy is reformation. Later on, we will be learning what reformation is. And then, B, the parties are also bound to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. Under consequences of perfection, we have here again an example. Imagine two individuals in Borongan City, Eastern Samar, Visayas, Philippines. Mr. Benjo, a local fisherman who owns a fishing boat, and Miss Clara, a businesswoman who wants to purchase fresh fish for her restaurant. They enter into a written contract with the following expressly stipulated terms. The object, Mr. Benjo agrees to sell, Miss Clara agrees to buy 100 kilos of lapu-lapu or a grouper fish at a price of 500 pesos per kilogram. And then they have agreed that it will be delivered on April 15, 2025. And then the delivery location is Borongan City Public Market. Let us now apply the reformation. Now let's say that Mr. Benjo and Miss Clara had a prior verbal agreement that Mr. Benjo would specifically deliver live lapu-lapu fish. However, the written contract mistakenly omitted the word live. When Mr. Benjo delivers freshly caught but not live lapu-lapu, Miss Clara might argue that it's not what she intended. In this situation, if Miss Clara can prove that their true intention was for the delivery of live fish, perhaps through witnesses or other evidence of their prior discussions, the proper remedy would be reformation of the written contract. The court could order the contract to be amended to include the word live, reflecting their original agreement. And then on the fifth subtopic, what the buyer should have made, as the Supreme Court held in Ursal versus CA 473 SCRA 52 2005, the perfected contract to sell imposed on a buyer the obligation to pay the balance of purchase price, and such being the case, the buyer should have made the proper tender of payment and consignation of the price in court as required by law in the case of Felix Plaza Urban Poor Settlers Community Associations Incorporation versus Lipat SR 821 SCRA 12 in the year 2017. We have here again an example of what the buyer should have made. Okay, we have the scenario. In Borongan City, Eastern Samar, Visayas, Philippines, Mr. Nonoy agrees in writing to sell his small vacant lot to Miss Fe for 100,000 pesos. They sign a contract to sell where Miss Elena pays an initial 10,000 as earnest money, and they agree that the remaining balance of 90,000 will be paid. I just had an error of typing. This is Miss Fe. Within 3 months, this signed agreement constitute a perfected contract. So in the simple terms, once Mr. Nonoy and Miss Fe signed the agreement, Miss Fe legally bounded to pay the remaining 90,000 if Mr. Nonoy refused to accept her payment. So Miss Fe couldn't just do nothing. To show she was serious and to protect her right to eventually own the land, she needed to formally offer the money and, if refused, deposit it with the court. This action demonstrates her compliance with the perfected contract to sale as emphasized by the Supreme Court. And lastly, a duly authorized to effect cancellation of an otherwise perfected contract. In a legal principle, when a contract is already perfected, meaning there is no consent or subject matter and cause, it is binding on both parties. Only those who are duly authorized by juridical person like corporation or company may validly cancel such contract. In other words, a company's agent or officer cannot unilaterally cancel a perfected contract unless they have proper authority, usually through a board resolution or a specific delegation of authority. This rule protects the contracting party, also the buyer, from arbitrary or unauthorized acts by someone who may not actually represent the company. I have here again a video. Okay, let's try again.
Crucial to understand the role of duly authorized representatives. Imagine a seller who is a corporation. This means an officer must sign on their behalf. But here's the catch. That officer must clearly indicate their authority to cancel a contract that's already been perfected. Without this clarity, the cancellation could be deemed invalid, leading to legal headaches. It's not just a formality, it's a safeguard for all parties involved. So, if you're signing on behalf of a company, make sure to state your authority explicitly. This simple step can save you from potential disputes and ensure a smooth transaction. Remember, clarity is key in real estate.
And then before I end my report, let me give you a short quote which states that, "Let us remember that well-formed contracts are not just documents, but the very scaffolding upon which successful endeavors are built." That's all for my report today. Thank you so much, classmates, and I'm sorry for the inconvenience.
Miss Fatima,
Yes, ma'am.
going back on your legal principle involving corporations, the same would apply, no? Even in the case of your city hall, for example, for the purpose of entering into contracts, it's not just the signature of the mayor, for example, that is required, but rather it requires that a Sangguniang Bayan resolution be issued to authorize the mayor to sign for in such contracts or memorandum of agreements, for example. Also, in the same light, you have at the end of the ESSU also, for example, it is also that the university president only acts upon authority given by the Board of Regents governing the SUC. So for that matter, it is not that the president signs plain and simple, no. He just affixes his signatures on contracts or agreements that the university would enter into, but rather that the Board of Regents authorizes the university president to perform that for them. So in essence, you are looking at the university president as a figurehead, no, but not necessarily the end all for all actions pertaining to the university. Hence, as we discussed earlier, hence the need to identify if the person has authority to perform that in behalf of the corporation or the institution. Okay? Secondly, on your discussion on the contract involving an actress, just so we can all relate it to, you must have heard or read on the news regarding the contract question by Nadine Lustre involving her contract with FIFA, because at that time she was questioning already her image and how she was presented to the public, far from her desired wholesome image. She was slowly being transitioned to become the adult figure. No? So on that count, she questioned her contract with FIFA. However, in court, the court ruled in favor of the agency, declaring that the contract between them was valid. However, it was also declared as a win-win for Ms. Lustre, claiming that despite the contract being valid, because of the questions she made upon that contract, she was given the discretion to determine how she wishes to be presented to the public. So, on that count lang, baka gusto nyo, the class might want to research on that, just to something to associate the principle with. Thank you very much, Ms. Pat.
Thank you po. Thank you po, Attorney. I think
Okay,
the
so thank
next
you,
presenter is
Fatima.
Miss
Next
Casiliano.
to her is Miss Casiliano. Ate Jane, when you're ready. Thank you.
Proceed lang sa reporting lang, Juna, ha? Please proceed lang. Thank you.
Thank you, Attorney. Good morning, Attorney. Good morning, classmates. Today I will be discussing Articles 1316 and 30,